There's truly nothing quite like watching a situation unfold where authority is put under pressure and every action is measured against the law in real time. Moments like these don't just entertain. They reveal how constitutional rights actually play out on the street, far away from theory and textbooks. Before we get into today's breakdown, I want to give a special shout out to Shaky from Tucson, Arizona, and Candy from Charlotte, North Carolina. I appreciate your support more than you know, and it's viewers like you who keep this platform going and growing. Now, just a quick clarification before we proceed. I am not a practicing attorney, and nothing in this video should be taken as legal advice. What I provide is educational legal analysis based on publicly available case law, constitutional principles, and established judicial precedent. The goal here is simple: to understand how the law applies in real-world situations. With that said, today's case takes us to Seneca Falls, New York. The date is July 29th, 2023. On one side of this encounter, we have Sergeant Eric McLean of the Seneca Falls Police Department. On the other side is Christopher Welch, a law student who, from the very beginning, appears to have a strong understanding of his constitutional rights. What initially starts as a routine traffic stop does not remain routine for long. As the interaction develops, it escalates into something far more complex, raising serious legal and constitutional questions about police authority, citizen rights, and the limits imposed by the Fourth Amendment. At the core of this encounter are foundational legal protections against unreasonable searches and seizures, and how those protections are applied during something as common as a traffic stop. To properly understand what is happening here, we'll be referencing key Supreme Court decisions, including Terry v. Ohio, which defines the standard for stop-and-frisk procedures, and Pennsylvania v. Mims, which addresses what officers are permitted to do during lawful traffic stops. As we go through the footage together, I'm going to break everything down step by step. At each critical moment, we will pause and analyze exactly what the law says, what the courts have ruled in similar situations, and whether the actions being taken align with constitutional standards. This isn't just a traffic stop. It becomes a real-time lesson in how legal authority is exercised, challenged, and interpreted under pressure. And whether you side with law enforcement or civil liberties, there's a lot to learn from how these moments unfold. If you enjoy detailed legal breakdowns like this, where we analyze real encounters and examine accountability through the lens of constitutional law, make sure you subscribe to the channel so you don't miss future cases. And if you'd like a shout out in the next video, don't forget to like this one, share it with someone who would find it interesting, and drop your name along with where you're watching from in the comments below.
How you doing, sir?
Hi, how are you?
Sergeant McLean with the Seneca Falls Police. Pulled you over because you have a headlight out on your vehicle?
You know, I was actually wondering that because it was a little like, you know, it wasn't lit up 100%.
Gotcha, yeah.
Yeah.
Okay, do you have a license on you?
I do,
Nice.
yes sir.
Where are you coming from tonight?
I'm actually just coming from my house to here to get some dinner.
Okay, everything valid on your license?
Oh yeah, absolutely.
Okay, how many alcoholic beverages you had tonight?
No.
Nothing?
No sir.
Okay.
Yeah, I was gonna get that.
Oh, I thought you were handing that to me.
Oh no.
Okay, alright. You have the registration for the vehicle?
You know what? I mean, it's legit. I just
Yeah.
don't have it in here.
Okay, is the car registered to you?
I think it's my girlfriend, Jennifer.
Okay. Just want to
It's one or the other.
Okay, just want to turn the car on real fast to see, just to verify the headlight is
Yeah.
still off. You just stay in the car, just let you know.
Yeah, no problem.
No, you're good. Just the passenger side one. You just stay in the car for now.
Okay.
Take a look at your license.
I think it's under her name or my name. I can't remember which one it's registered under, but
It looks like it's maybe your wife Sindoni. Is that
yeah,
your
it's my
girlfriend or what?
woman. Yeah.
Gotcha. Okay.
Yes, sir.
All right, you're all good. You said no alcohol tonight.
No, hell no. I don't drink.
You know, okay. I
No.
smelled something fruity. What's that? Is that?
I don't know. Probably my Pepsi or something.
Okay. Yeah.
Yeah, I don't know.
You gotta take a look at your eyes real
Absolutely.
quick. If you don't mind.
Nope. Go
Just
on.
looking for impaired drivers. This
Oh
evening.
yeah, I don't take those tests.
You don't?
No.
Why not?
I just don't. I don't take tests, sir.
Okay. Well, I'm asking you. I'm gonna make sure you're okay to drive your vehicle.
Yeah, no, I understand. I don't take tests though.
Okay. Why not?
I just don't. It's no disrespect to you.
No, I am performing an investigation right now.
Okay.
to make sure you're okay to drive your vehicle.
Yeah, I won't. I don't take tests, sir.
Why not?
I just don't. I mean,
Okay.
I take, I am a law student for one, and two, I just don't take tests.
All right, sit tight for me, please.
Okay.
Got it. Here's a shorter, tighter, high-retention version while keeping your legal tone and narration style strong. Right off the bat, Sergeant McLean initiates a traffic stop for a defective headlight. And legally speaking, this part is solid. Under New York Vehicle and Traffic Law Section 375, all vehicles must have working headlights, so the stop itself is fully justified. This also aligns with Delaware v. Prowse, 1979, where the Supreme Court confirmed that officers can lawfully stop a vehicle when they observe a traffic violation. So at this stage, there's no constitutional issue. But things start to shift quickly. After confirming the headlight issue, the officer immediately pivots to asking whether Mr. Welch has consumed any alcohol. And this is where the Fourth Amendment becomes important. Under Rodriguez v. United States, 2015, a traffic stop cannot be extended beyond its original purpose without independent reasonable suspicion of additional criminal activity. Mr. Welch denies drinking. Despite that, the officer claims he smells something fruity and begins focusing on his eyes, clearly building toward field sobriety testing. Now here's the key point. In New York, field sobriety tests are generally voluntary. They are not the same as chemical tests under implied consent laws, so refusal does not carry the same automatic legal consequences. And Mr. Welch refuses. What makes this more interesting is that he identifies himself as a law student. That suggests he understands his rights, especially under Terry v. Ohio, which allows brief investigative stops, but does not allow officers to compel cooperation beyond what the law permits. So what we're seeing here is a routine traffic stop that quickly turns into a legal test of boundaries between police authority and constitutional rights.
What's up, man? Thanks for coming by. So I pulled over for a headlight. I'm smelling some sort of alcoholic beverage. Smells like it's a fruity drink from the side of his vehicle. I said I could check his eyes in his vehicle to see if he's willing to perform any sort of test. He goes, no, I didn't do tests.
He's not doing any tests?
I want to see if you get the same odor when you go up there.
Okay.
See what you think.
I'm going to go get my flashlight.
Sure. You get that odor too. I observed him with glassy, watery eyes.
Okay.
So he's coming here to get food, but I'm trying to see if you get the same clues that I'm getting.
How are we doing tonight, sir? Where are you coming from tonight?
I don't answer questions.
You don't answer any questions?
No, I'm
Why?
not.
Why is that?
Because he's trying to give me tests, and he's accusing me of drinking.
No, I just
and
asked you a question, sir, to perform sobriety
I
tests.
understand, sir.
Right, I'm conducting an investigation
I
right now.
I don't drink for number one.
Okay.
And you're asking me if I've been drinking, sir.
Right.
I don't drink.
Okay. I don't know that. I never met you before.
Well,
It's just an investigation to make sure you're safe to
No.
drive, all right? That's all it is.
I understand, sir, but
Okay.
I don't answer questions. There's no disrespect, but at all, you know what I'm saying, at all.
I understand, yeah.
Sonic all units, hold here for your
I'm
state
coming here to
Sheriff's
get
Department
dinner
out
for my
domestic violence.
family. And, no offense, but I feel like you're
All
kind
units,
of coming on a little
No,
strong.
I'm just doing my job, sir.
And just because a vehicle smells fruity,
No, a fruity
Doesn't
alcoholic
it-
beverage, like I stated to you, sir.
yeah, well,
You also have watery and glassy eyes.
Of
Another,
course,
another,
sir.
another sign of
And
intoxication.
I have sinuses, I have
Okay.
allergies, I also have asthma.
Okay.
as well.
Okay. Does that cause your eyes to get watery
It
and
does,
glassy?
yes, sir, absolutely.
Because I also have asthma.
Absolutely, sinuses does, yes, sir.
Okay.
But
Alright.
you have no issue. If you're not drinking tonight, there's no issue taking a test.
I don't take tests, sir. I just don't do it. I'm sorry. I'm sorry.
Okay.
Do you have a supervisor?
I'm a supervisor on scene.
Do you have a supervisor?
I'm a supervisor working right now.
Okay. Do you have one available?
No, I don't.
Speak
I'm
up.
a supervisor right now, sir, of the shift.
Okay.
I'm asking you to exit to make sure you're okay to drive right now.
I'll exit, sir. I'm not gonna just not obey.
And I appreciate that.
You want me to exit?
I want you to exit to make sure you're okay to drive.
Give me a command.
I'm giving you a law order to exit your vehicle
Yes,
to make
sir.
sure you're okay to drive.
Yes,
all right.
sir.
That's all I'm doing.
You want me to my wallet?
You don't need your wallet or anything.
Again, I'm not taking any tests, sir. So I don't know what you're. You okay to put this in my? Is this okay?
You're nothing on you?
That's
Nothing?
fine.
Mind if I get you
No,
quick
sir.
back down for
I
weapons
do
or anything?
mind. Yes, sir. I don't.
Well, it's
I
going to be an
don't-
officer safety check. I'm
I
just
don't.
gonna
I
do-
don't comply.
It's just going to be a quick back down for our safety. That's all it is.
If you have to do it,
I'm not going to hold anything,
no,
okay?
go ahead. If you have to do it, this is embarrassing.
It's not embarrassing.
I
It's for
run
our
a
safety,
business.
sir.
I run a local
And
business.
I'm not.
This
There's nothing
is-
against you. If you get out of the
this
car,
is-
I just want to make sure this is your wallet. That you put your wallet in. Okay.
I don't answer questions, sir.
I'm just double checking for officer safety.
No.
Here's
this is
a
where the
tighter,
legal-
polished, high-retention version of your paragraph, with improved clarity, pacing, and stronger narration flow while keeping your legal breakdown style. Now this is where the legal nuance really matters, and it's important to slow this down so people fully understand what's happening. What we just witnessed is Mr. Welch exercising a right that most people don't even realize exists. In People v. Berg, the New York Court of Appeals made it clear that refusing field sobriety tests carries no statutory penalty. None at all. These tests are purely preliminary tools used by officers to help establish probable cause. They are not mandatory under the law. And here's where confusion usually happens. New York's implied consent law, under Vehicle and Traffic Law Section 1194, applies specifically to chemical testing or urine tests administered after a lawful arrest. Refusing those tests can lead to automatic license suspension and other legal consequences. But field sobriety tests? The walk and turn, the one-leg stand, the eye movement examination Sergeant McLean was preparing to conduct. Those remain completely voluntary. Now watch the officer's response the moment Welch refuses. The situation immediately escalates. Backup is called, and the focus shifts toward building a case based entirely on observation, glassy eyes, a fruity odor, and behavioral indicators. But here's what's important to recognize. Mr. Welch offers alternative explanations, conditions like allergies, asthma, or sinus issues. And medically speaking, these can absolutely produce symptoms that officers are trained to associate with impairment. So what we're really seeing here is a legal misunderstanding of two separate frameworks. One governs voluntary roadside cooperation, and the other governs mandatory post-arrest chemical testing. They are not the same, and they do not carry the same consequences. And based on the way this interaction unfolds, it's clear Mr. Welch understands that distinction, even if the situation around him continues to escalate.
What I'm asking here is if you had any alcoholic beverages tonight. I'm getting clues of
I
intoxication.
answered your question, sir.
I understand
I do
that.
not drink. If you're
Okay.
getting any clue of intoxication, you need to go back to school.
I've been a cop for 8 years. I know what signs of
Sir,
intoxication
I'm
are.
being honest with you.
Okay. Well, I don't know that. I never
Okay.
met you
Well,
before.
I'm being honest with you.
People have told me a lot of things in the past. All right.
Yep.
So what I want to do is check your eyes, make
I'm
sure you're okay to drive.
absolutely not doing that, sir.
Would you be willing to walk for me?
No, absolutely. Absolutely not.
Okay.
I
Why
can't
is that?
believe that you think I...
No, if you had nothing to drink tonight, this would show that you had nothing to drink.
Sir, I'm not doing that.
Why is that?
Because I do not. I've been through law school and everything else. I do not comply.
You don't comply with the lawful order?
Sir, I've answered your question.
All right. What I'm giving you is a lawful. I'm giving you an
Sir,
order.
I'm telling you, you're giving me an order to take a test.
I'm advising you to take sobriety tests to make sure you're okay to
Sir,
drive your
I
vehicle.
will not take a test. No
Okay.
disrespect.
We're not trying to disrespect you either.
You are, because
No,
you
sir.
keep asking me multiple times.
Sir, we have a job to do. Okay. That's all it is. It's no disrespect towards
I've
you.
answered your question.
We get
sir.
lied to
I will
every
not
day.
take any tests. I will not, and it's no disrespect. I have a lot of friends that's law enforcement. You know what I'm saying? I would not disrespect in that way.
We
Right.
appreciate
It's
that.
just
We're not
I do
disrespecting
not
you either.
take tests. I do not. In fact, I've dealt with you before previously.
Recall when I
I
dealt
was
with
in
you.
Rittmer Lane before you came to my house and asked me a bunch of questions.
Okay.
Also, you know, again.
Oh, was
I
that
felt
about
like,
was that the Uber thing?
Yes, sir.
Okay, I do
Yes,
recall you
sir.
now. Okay.
And I was more than respectful.
I know
to
you were,
was I
and
not?
I appreciate
I'm a
your
little
cooperation.
nervous because here I am at Burger King, getting dinner for my family.
Right.
You know, and I get nervous when I speak to cops because I just
We're just here to do our job. We're not here to.
get it. But you
Not
pulled
to-
me
yeah.
over for a headlight.
That's correct.
Okay.
Yep.
Now you're pushing it.
I'm
you're
not pushing
saying,
you. I'm just doing an investigation.
You're
right
claiming fruity alcohol. You're saying something that smells fruity. So
now. I have fruity alcoholic
there's a million
beverage.
things. I deliver groceries for
Okay.
Walmart, so maybe
Like I
something
also said, you
slipped
have
out,
you
know
have
what I'm
water
saying?
and glassy eyes. That's a
Okay.
sign of intoxication.
Many people have that, sir.
Okay. Well, I don't know. I never.
Just because somebody has glossy eyes doesn't mean anything.
Yes, it's a sign from our training and experience.
Okay.
It's a sign of
and I'm-
intoxication.
Okay, well, okay. So what are you going to do with this, sir?
Sit tight, let's just
Yeah,
get real
absolutely.
fast.
Absolutely.
I'm always done.
Here's
Hold on,
a more
did you catch that?
polished, tighter, high-retention version with stronger clarity, legal precision, and narration pacing. Hold on. Did you catch that moment? I've dealt with you before. Sergeant McLean has now effectively acknowledged prior interactions with Mr. Welch, referencing what he calls the Rittmer Lane incident and an earlier Uber-related situation. That detail matters, because it introduces context that goes beyond a routine traffic stop. This is no longer a completely isolated encounter. It carries history. Now let's break down the legal framework the officer keeps relying on. He repeatedly uses the phrase lawful order. But we need to separate what the law actually says from how it's being applied in real time. Under Pennsylvania v. Mims, 1977, officers are absolutely allowed to order a driver out of a vehicle during a lawful traffic stop. That is well-established precedent. However, Mims is limited in scope. It authorizes minimal safety-related intrusions, not compelled participation in investigative testing. And that distinction is critical. The Supreme Court has never equated being lawfully detained with being required to submit to voluntary field sobriety testing. Those are two very different legal categories. One concerns officer safety and control of the scene. The other involves investigative procedures that are not mandatory unless separate legal thresholds are met. What we're seeing here is the officer framing refusal as potential obstruction, repeatedly labeling his commands as lawful orders. Even though the underlying actions being requested, field sobriety tests, remain voluntary in New York. That's where the legal tension begins to build. Because under Terry v. Ohio, reasonable suspicion must be based on specific, articulable facts tied to the individual in front of the officer, not assumptions, prior experiences, or generalized distrust. An officer cannot dismiss innocent explanations simply because they've encountered dishonest individuals in the past. Each stop must stand on its own facts. Prior encounters with other people, or even prior encounters with the same individual, do not automatically elevate suspicion unless there is fresh, objective evidence supporting it in the current situation. And that's the key issue here. The officer is building suspicion while simultaneously rejecting alternative explanations, which raises an important question about how reasonable suspicion is actually being formed in this encounter.
It's so weird. 'Cause I just literally replaced that one back like
Right. Okay.
shit.
But you can do that. You can go
Nah.
home and you can get inside. And you can
Yeah,
stay
it
at home.
wasn't too long ago.
Okay.
So yeah,
There'll be a fix-it ticket for the headlight, and then
Okay.
you'll have until Monday to get it fixed on.
till Monday.
Yeah, because it's
Okay.
usually the next business day. But
Now, what do I do with that? Do I bring it
Just-
to the sheriff or not
You
sheriff?
can go.
to the-
Literally, you can go to any. You can go to a mechanic to sign off on it.
Okay.
A law enforcement officer. There's
You're gonna write me a
instructions.
ticket just for that? For real?
We're doing traffic enforcement tonight.
You cut me out here all this time. You're gonna write me a ticket for that?
Doing traffic enforcement, sir.
All right, buddy. What's your name, sir?
Sergeant McLean.
Do you have a card?
I do have a card. It'll be on the, my name will be on the ticket as well.
All right, sir. I
All right.
appreciate
Just give me a
you.
moment, please.
Thank you. Appreciate you guys.
I was calling to see if we could do a possible obstruction charge for not wanting to provide submit the standard field sobriety test. You can do an obstruction charge.
Kept backing away from me, so I don't.
So did you get? I got a whiff of like a
In-
fruity alcoholic beverage.
in the car.
Yeah, that's the odor I was getting from
In
the
the
vehicle, which is
car.
what I explained to him, and
Yeah.
then his eyes were glassy and watery.
And then I couldn't, like, he kept backing
Okay.
away from me when I was trying to talk to him.
Right. Okay.
And then, but he wouldn't, like, I couldn't get a strong
He's
enough.
also steadying himself on the hood of the car. He was talking to us. He kept touching it.
But his eyes were glasses.
All right, sir. So you got a citation for inadequate headlight.
Okay.
So, you wanted to speak to a supervisor of mine. So
Okay.
I notified my lieutenant on the phone.
Okay.
He's aware of what's going on.
Perfect. Thank you.
So I can't determine if you're okay to drive or not.
Mm-hmm.
So you refused the sobriety test.
Yes, sir.
I told you you have signs from my training experience of intoxication.
Yes, sir.
You have slowed, mumbled speech.
Mhm.
You have watery and glassy eyes.
I know
All
what
right.
you said, sir.
Okay, and I
Yes,
smell
sir.
an odor of an alcohol beverage emanating from inside the vehicle.
Okay.
So I don't know if you
Sir.
can drive or not. So you're gonna have to call someone to pick you up to drive.
Okay.
Understood? So that's what.
Okay. You want me to call someone right now?
That's correct.
What am I gonna do with this vehicle? Leave it here overnight?
I will let them know to stay here.
Here's
And there
a
it
Titan,
is.
high retention, professionally polished version with stronger clarity, pacing, and legal framing while preserving your tone. And there it is, right on camera. We just watched Sergeant McLean attempt to explore whether refusing a voluntary field sobriety test could amount to obstruction. He even pauses to consult another officer about whether Mr. Welch can be charged simply for declining to participate. The answer comes back clearly no, because that is not how the law works. But what happens next is where this encounter shifts into a far more serious constitutional discussion. At this point, the officer has not established probable cause for a DWI arrest. There's no chemical test, no formal arrest, and no definitive legal threshold met. Yet despite that, Mr. Welch is now being told he cannot drive his own vehicle home. Instead, he is ordered to leave it on the roadside overnight and arrange alternate transportation. So let's be precise about what that means legally. This is not just a traffic instruction. This is a restriction on both movement and property without an arrest, raising direct Fourth Amendment concerns regarding what constitutes a seizure. Now, the Supreme Court in KDV Dombrowski did recognize a limited community caretaking function for police, allowing certain non-investigatory actions tied to public safety. However, that doctrine is not unlimited. In fact, New York courts have narrowed its application significantly. In People v. Brown, the Court of Appeals made clear that community caretaking cannot be used as a pretext for investigative detention or to justify restrictions that exceed what is genuinely necessary for immediate public safety concerns. And here's the critical contradiction in this moment. The officer openly states he cannot determine whether Mr. Welch is safe to drive, but that uncertainty is legally significant in both directions. If there is insufficient evidence to determine impairment, then there is no probable cause for an arrest. And without probable cause, you cannot lawfully impose restrictions that effectively amount to a detention of either the person or their property. The Fourth Amendment does not allow freedom of movement to be restricted based on vague suspicion, uncertainty, or subjective impressions like glassy eyes or environmental assumptions. The community caretaking exception requires specific, articulable safety concerns, not a substitute for lacking probable cause. And what we are seeing here is the tension between that legal standard and how the situation is being handled in real time.
Okay.
Okay.
All right. Yeah, let's do that. Sounds good.
So that's issue
All right, sir.
your license.
All right.
You wanted a business card as well, you said?
I do. Yeah.
So
I'll grab my phone.
that's fine. Like I said,
Oh, that's all right. We can play this game.
I'm not playing any games,
Oh,
sir.
sir, you're being very disrespectful. I will file a complaint.
I've never been disrespectful to you.
Sir, you are being
this,
very
This
disrespectful.
is all recorded on body
You
camera.
have pushed this above and over a
I have not, sir.
Okay.
This is all recorded on body camera.
Excellent. I appreciate that.
No problem.
I have it all recorded as well, sir.
That's fine.
I guess that's it then. Yeah,
All
just
right,
give me
I'm
your
gonna
number.
give you. Yep. Here's the contact number.
You have a citation?
Here's a citation. You have a court date of August 14th at 12 p.m. in Town Center Cross Court.
Yes, sir.
For the correction ticket, you have to get it corrected by Monday
I will. Yes, sir.
and have it signed off by a mechanic or a police officer. Okay.
You got it. Yes, sir.
There's my business card right here, sir.
All
Here's
right.
a citation. Like I said, my lieutenant's been made aware of the
Here,
situation.
Lieutenant. What's his name?
Lieutenant Clear.
Clear. Yes, sir.
He's been made
Okay.
aware of the situation.
Okay.
All right.
Yes, sir.
Any other questions for us, sir?
That's it.
All right. Have a good rest of your night.
Here's a shorter,
So that's how
tighter, high-retention version of your ending, while keeping the impact and narration strength. So that's how this encounter ends. A citation for a defective headlight, a business card, and a traffic stop that never escalated into an arrest. But what we just saw goes beyond a routine stop. It highlights what can happen when someone understands their constitutional rights and doesn't unknowingly waive them under pressure. Christopher Welch complied where required, license, registration, basic cooperation, but he also refused what the law does not require, including field sobriety tests, which in New York are voluntary and carry no penalty for refusal. When obstruction was considered, a supervisor confirmed what the law already makes clear. Refusal alone is not obstruction. To be clear, I'm not a practicing attorney, and this is not legal advice. This is an educational breakdown based on established case law. The stop itself was lawful under Delaware v. Prowse, but what followed raises important questions under Rodriguez v. United States about extending a traffic stop beyond its original purpose, without independent reasonable suspicion. We saw a shift from a simple equipment violation to alcohol-related questioning, pressure for voluntary tests, and attempts to escalate refusal into wrongdoing, all of which exist in a legally gray and often misunderstood space for most people. And that's the real issue here. Most citizens don't know what they can legally refuse and what they cannot. That gap in knowledge often leads to compliance out of confusion, not obligation. Cases like Terry v. Ohio and Pennsylvania v. Mims exist to define those boundaries clearly. Field sobriety tests remain voluntary. Refusal is not obstruction. And suspicion alone does not replace probable cause. This isn't about being anti-law enforcement. It's about ensuring constitutional standards are applied consistently. If you want more breakdowns like this, subscribe and drop your name and where you're watching from for a shout out in the next video. Stay informed and know your rights.